Good morning, ladies and gentlemen. Thank you very much for your patience, especially for those who were there even before time. Welcome to our webinar about the impact of Brexit on the GDPR obligations for Belgian and Luxembourg companies. So as I mentioned already before, it is a very important subject, and it is one which is often forgotten, which is not a good thing, because it is a very important one. And it's probably slightly forgotten because as part of the deal, the EU agreed the delay of the transfer of, or the restrictions about the transfer of personal data was delayed until the end of June. So that's in 30 days time, if we count as from today. So this is coming to an end, and we really recommend as a chamber that you put alternative solutions in place. And I'm delighted to have two real experts here who haven't started this just because of Brexit, but who have already a very long track record and hence experience in the field. So we have Jane Murphy, who's the founder and chair of the board of EDPO. It stands for the European Data Protection Office, and Romane, who's the data protection representative of EDPO, and they are both based in Brussels, but they deal with the whole world. So it is a truly international company, but as I said, a track record of dealing with GDPR issues. So without much ado, I would like to pass on the word to Jane and Romane. Thank you for joining us today.
Thank you very much, Michel. So as Michel said, I'm the founder and chair of the European Data Protection Office, EDPO, and also of EDPO UK. So we have offices also in Brussels, like Michel mentioned, but also a separate company in the UK. And our offices are at the same building, are actually in the BLCC, where Michel is also. So I'm a GDPR lawyer, I'm a corporate lawyer also, and so we're specialized in EU and UK data protection representative services, and this is one of the topics that we'll be discussing today. I'll briefly let Romane introduce herself also, although Michel has very kindly introduced us. Maybe you want to say a little word, Romane?
Yes, thank you, Michel, and thank you everyone for being here. My name is Romane in English. I graduated with a legal degree from the UC Louvain with a specialization in the GDPR and data protection, and I work as an account manager for EDPO and EDPO UK. So I work for both companies in Brussels, in our other offices in the EU, and in London as well.
Great. Okay, so today the topic, as Michel said, what's the impact of Brexit on your companies? We tried to make it as practical as possible, not going to too much detail, but really explain, what you need to do by the 30th of June and anything after that, any additional obligations, and basically, what are the important aspects that you need to look into. So today's agenda, we'll look at these obligations, first of all. The second thing that we're going to look at is the forgotten obligations. So Michel was saying that the GDPR in itself, the impact of Brexit, is a bit forgotten, but there's even, a more forgotten obligation, and that's to appoint an EU representative. And you will see that it's not very complicated, but so many people don't know of this. And this is one of the reasons why we're trying to do webinars like this, is to raise awareness on this topic, because it's very, very important. What measures that you should put in place to stay compliant, both with the EU GDPR, but also with the UK GDPR, because we'll see later that the UK GDPR also exists. It's a separate GDPR. And then tips on how to prepare for your 30 June deadline. So, and then we'll finish up with a question period. But as Romane was saying at the very beginning, feel free to use the Q&A down below. You just click on there and put your questions in there, and we'll try to answer them as we go along. No problem pausing or whatever, but in any event, at the end, there'll be a specific period so you can ask your questions.
Yes.
Let's get started. So what's the impact of Brexit on your company, specifically, in Belgium and Luxembourg? What do you need to look out for? So maybe it's important to start with the basics, but not too much detail, as I said, just to see where we're at now and what has changed. So if your companies are based in the EU, so Belgium and Luxembourg, and even in the UK, you know, you have had to comply with GDPR since 2018. So you're probably already, hopefully, compliant or as compliant as you could be, because nobody's always 100% compliant every single day. So up to the lead to the withdrawal agreement in 31 December, January 2020, you should have already been GDPR compliant. Then comes the withdrawal agreement. So what happens then? Well, there was a what we call the transition, the Brexit transition period, and that was until 31st of December, just past now, of 2020. And this transition period concerned all data protection matters. That means that anything related to GDPR continued as it was before the withdrawal agreement. No changes either way, either in the EU or the UK, business as usual. Then on the 24th of December, there was a trade and cooperation agreement, and there was a new transition period. And that transition period is up until the 30th of June. Contrary to the first transition period, this transition period does not concern any other aspect of the GDPR except international data transfers. That means that there's a principle that says you can't transfer personal data outside of the EU. And so the EU Commission said, okay, for a period of up to 6 months, so the end of June, 30th of June, we'll pretend that these restrictions don't exist. So you go on and do business as usual, but only for that aspect of the GDPR. So what happened as from the 1st of January when Brexit came, you know, full speed into our lives? Well, the UK became a third country to the EU, same as, you know, the United States or Japan or any other country that's outside of the EU, full-fledged third country in terms also of GDPR. And then the GDPR was kicked in the UK version. So it's called actually the UK GDPR, and it's basically a copy paste of the EU GDPR with the same obligations, the same article numbers. So it was adapted in a few areas here and there, but it's basically all the same. So the same rights, obligations, principles, and all the, you know, all the rest stays almost 100% the same as the EU GDPR. So it shouldn't be a big surprise. So prior to the Brexit, prior to Brexit taking effect, the UK had already, in terms of international data transfers, confirmed that for transfers of personal data from the UK to the EU, that would be permitted. So no extra steps needed to be put, no transition period, nothing changes. Any company in the UK transferring data to the EU can still do that, and, you know, even after the 30th of June, with no restrictions, no barriers, no obstacles. That stays the same. The issue is what happens to transfers from the EU to the UK, and we'll get into that now. So that is what we're in now, that transition period, only for the transfer of data, personal data outside of the EU.
I'm sorry.
Oops.
There we go. It works. Sorry.
Okay. So this is the most common misconception. This is a mistake that so many people are making now, is saying, I don't need to be compliant with the UK GDPR because we're in the transition period. That is not correct. As the 1st of January, you need to be compliant with both. And one of the obligations that you're not used to as an EU company is having to appoint a UK representative if you do business with the UK. We'll look into the specifics of that in a couple of minutes, but that is something you have to keep in mind. The two transition periods are completely, the scope is completely different. So remember that until the 30th of June, transition period only for international data transfers. Come on. Yep. So there are two main impacts of Brexit on your Belgium and Luxembourg companies. The first one is that if you don't have an establishment in the UK and you offer products or services to the UK, then you fall under the UK GDPR, and under Article 27 of the UK GDPR, you need to appoint a UK representative. Romane will tell you in a few minutes exactly what that entails. I just know that unless you fall under some specific exceptions, you have to appoint a UK GDPR representative in the UK. The second thing, and that we just went through it, is international transfers of personal data. Any transfers to from the EU to the UK, you have to look into that. What are you going to do after the 30th of June? So those are the two main impacts. Maybe Romane, you can take it from here on the representative.
Yes. So about the forgotten obligations, as we said, of the appointing an UK, representative. What you have to know is the UK GDPR representative has three main obligations to fulfill. So as Jane said, pursuant to Article 27 of the UK GDPR. First of all, the rep acts as a point of contact between the data subjects and the company it represents. Second of all, it acts as a point of contact between the Data Protection Authority. So in this case, it's the UK Data Protection Authority, so the ICO, and the company it represents. And the third obligation is to keep a copy of the company's record of processing activities. So practically speaking, what does it mean? Being the point of contact means that the contact details of the representative will have to be shown somewhere on the company's website, or even better, on the company's privacy policy, because it's usually where you find all the information about data privacy and everything. So the contact details of the representatives must be shown on the privacy policy, so that the individuals or the Data Protection Authority can choose to contact the representative instead of the company. So they don't have to, but they can if they want. If they want, for example, to exercise their rights under the UK GDPR, for example, the individuals, or if an authority, in this case, the authority in the UK wants to help a data subject with their complaint, or want to do an investigation, want to ask a question, any type of request really. So what we do as representative is we liaise with the company, so with your company, and we help you handle the requests that come through us, but for the company. And about the third obligation, to keep a copy of the record of processing activities, so that what we call the ROPA, you might already be familiar with it, because
you should actually.
You should, because it's already in Article 30 of the EU GDPR. So same for the UK GDPR, Article 30. It's, for those who don't know what that is, it's a simple summary of your processing activities. What we have to do as a UK representative is to keep a record of these processing activities regarding the UK personal data. So we don't need any information regarding the EU personal data that you process, or any international type of data you process, only the UK part. But so if you have already one that is ready and concerns EU personal data, you should also have one for the UK personal data. And the rep just has to hold a copy in case, a data protection authority might ask to provide it. It's what it said in Article 27 and Article 30. So this is for the main obligations. Now, representative might add other services to that, but this is the main part and what's mandatory in the GDPR, UK GDPR. And also what's good to know is that the representative must be based in the UK, obviously, and must be appointed by a written mandate agreement. Now, the big question is, do you actually need to appoint a UK representative? Well, as Jane mentioned a little bit earlier, you must appoint a representative if you complete two conditions. So the first condition is if you do not have an establishment in the UK. Well, okay, the first condition seems already a little bit abstract, because what is having an establishment in the UK? So if you have an establishment, it can be anything from an office, a subsidiary, a branch, any type of presence in the UK means that you probably have an establishment there. If you do not have an establishment there, you are good with the first condition, then you go on to the second condition. If you provide goods or services to people in the UK, or if you monitor the behavior of these individuals. Again, this can be tricky. So providing goods or services means that you provide goods or services even for free. So it does not have to include payments. And monitoring the behavior of individuals can mean anything, from tracking and profiling the behavior of individuals. So for example, via the use of cookies on your website, if you, for example, track the visitors that come and go through your website, and if you keep information on them to do some marketing activities, maybe that's considered, for example, monitoring. So it's quite large, the conditions are quite large, both of them. So yeah, in this case, if you meet both conditions, you have to appoint a representative in the UK.
Romane, sorry to interrupt. We have a question from Cedric. Only if you provide goods or services to people or also to companies? So yeah, that's a question we get all the time. So thank you, Cedric, for that. If you offer goods or services to individuals in the UK, okay, that's obvious, but it also applies to B2B, B2C situations, because when you're doing that, you're offering to companies, but you're also processing data of individuals most of the time. So if you're also collecting email addresses and names of your partners or the companies to which you're offering services or the products, you're collecting personal data. So unless you could show that, you know, you're just dealing with, well, it's hard to show actually, no names and just generic email addresses like accounting at or customer support at or something like that, where there's no collection of personal data, then you should be off the hook. But if it's, you know, if it involves personal data, even if it's B2C relationship, then you'll still fall under the scope most of the time. But again, it's a case by case analysis, but that's the general rule.
Well, maybe the examples might help. I see that we have a second question in the Q&R part. So I don't know, Jean, if you want to answer that before I go on to the examples.
Does an AOS in the UK work? What is an AOS?
I'll just go on with the examples and maybe
Carol, if you can just tell us what an AOS is, please.
But so maybe it'll help with some examples.
Address of services. Sorry, Romane. Yeah.
Sorry, I don't have the
address of services. No, it has to be more substantive than that. It has to be a presence where you'll be able to answer the request of data subjects, the request of the Data Protection Authority. It has to be intrinsically linked to your activities. So if it's just a postal address or something, it's not serving the purpose of having a presence in the UK to be able to deal with GDPR matters. So it has to be something more substantive than just an address of service.
All right. So on to some examples, as I said. So let's say you are a company in Brussels that maybe exports chocolate to the UK, typical Belgian business. Here, I mean, you can see clearly that you are selling products to the UK and it's B2C. I think there's a mistake right there. We got it.
But it could be to individuals also. If you're selling directly to individuals, it could be.
So you can sell directly to customers. If you sell directly to customers, it's going to be B2C, but you can also sell to, you know, subcontractors and companies or shops or whatever. Then it's going to be B2B, but it also works. So you might need a UK representative because you process personal data of UK individuals in that case. So second example, if you're a company in Leuven that sells bike parts to UK companies or manufacturers online, in this case, you know, it's clearly, again, there's a mistake. I'm sorry.
It's the opposite way. B2B.
Yeah, it's B2B in that case, but products again, but B2B because you're clearly not selling to customers directly. Doesn't matter. You're still in the scope of this obligation. We have also a charity organization in Antwerp having contributors in the UK. Here, just this example to show that it also works for non-profit organization. They also fall within the scope of Article 27 of the UK GDPR. So UK representative might be needed. Then a fourth example, you're a company in Belgium or Luxembourg, really doesn't matter, that provides IT consultancy services to UK startups. So there you have it. It's not products, but it's services that you might provide, and it's B2B because you provide to other companies, whatever the size really, and you also fall within the scope of this obligation. And last example, if you're a law firm, for example, that's based in Luxembourg or Belgium, and that provides legal services to UK companies or individuals, also they're B2B or B2C, and it's legal services, so they also fall within the scope of the representative obligation. So we see that it's really a large scope, you know, to fall within. So, and then obviously there's some exceptions to this obligation, as Jane mentioned. So you do not need to appoint a representative in the UK in these cases. If, first of all, you're a public authority, that speaks for itself. Or if you have an establishment in the UK. So as Jane rightly mentioned, you know, if you have an establishment, you do not need a rep because it means that you have a presence in the UK and that you are able at the end to actually maybe handle the request from there. If the data protection authority wants to contact you, you are able to at least receive and handle the request. So it's really this idea of having a presence in the UK. So if you are already based there, you don't need a rep. And the last exception is if you carry out processing activities only occasionally, on a small scale, and at low risk for individuals. So these three conditions are cumulative in the last exception, so they only work together. And what we get the most as a question is, what is occasional? Because it's really not that clear. Again, not defined in the GDPR, but this must be, you know, it must be understood as, so it has nothing to do with volume. Occasional means if you do the processing only almost by accident, if it's not part of your regular activities, the regular part is really important. So even if it's, it's almost by accident. So for example, if you send a newsletter once a month to your UK customer, you can say it's occasional. It's not, it's regular, because even if it's one small, email marketing campaign and you send to 2 people, it's still part of your regular marketing activities. So the occasional part is really by accident, I mean, if you want to remember that. So these are the 3 exceptions to appointing a representative. And go back to you, Jane.
Yeah, okay, so let's get back to the international transfers. So what do you do if you have to transfer data from the EU to the GDPR? But the first question is, do you even know if you're transferring data from the EU to the UK, to the GDPR, I said, right? From the EU to the UK, sorry. So do you really know what you're doing? And a lot of people, don't feel bad if you don't, but a lot of people don't realize that they're actually transferring data because it's part of their day-to-day activities, and they don't really understand, what the flow is. So here are a couple of practical examples that you can look into and see if it applies to your companies also. So for example, if you use the CRM, so a customer relationship management system, or a marketing software that's in the UK, that means that your database, your clients, and people you send newsletters to, your emailing list and things like that, if they're based in the UK through an application or through a server or just in the UK, you're actually transferring all this personal data to the UK, although your activities are only in Belgium or Luxembourg or in Europe, and you're not exporting any products or services. The fact that type of data is in the UK means that it's an international data transfer to the UK. Another example is if your clients, you have a website and your clients can pay online, and the payment application uses UK-based servers. So all the financial information, the payment information is going to be in the UK. That's also an international transfer of data from the EU to the UK. If you transfer your customers' orders to manufacturer located in the UK, for example, you're a bicycle shop in Belgium, and you take orders from people in the EU, from Belgium or elsewhere in the entire EU. So you're not exporting anything to the UK, but you have parts that are made there in the UK, or the bikes are assembled there, or whatever. As long as, if you're sending your customer information, the name and the delivery address to your manufacturer or partner in the UK, and they're delivering then directly to the customers in the EU, you're transferring personal data to the UK. So it's really something that you have to carefully look into, look at your processing activities, look at all the applications that you use, and really, note which ones involve the UK, and then see what measures you need to put in place. And we'll see that a little bit later. Okay. So if you go through that exercise and you say, I do transfer personal data from the EU to the UK, what do I do? So as mentioned earlier, the underlying principle is, if we abstract the transition period, as a general rule under the EU GDPR, you are not allowed to transfer personal data outside of the EU to third countries unless you have sufficient protection mechanisms in place. You only need one normally, and these are the different mechanisms. We'll go through them, not in detail so you don't die of boredom, but just very quickly to make sure that you're compliant. So until the 31st of June, what do you need to do? The 30th of June, absolutely nothing in terms of, strictly legally speaking, all the transfers continue to be legal. So you have nothing to do. As from the 1st of July, what happens? Now, if the European Commission grants an adequacy decision to the UK, then you can continue after the 1st of July to continue to transfer personal data outside the EU to the UK. Nothing changes. So what's an adequacy decision? So an adequacy decision is a decision that the EU takes after analyzing the country of the importing country, if you want, or the country to which people export the personal data, and looks if that country grants or gives sufficient protection or adequate protection to the personal data that's going to be transferred. And you have to know that there are not many countries that benefit from such an adequacy decision. There are 12 of them. There's like Canada, Japan, Israel, Uruguay, and so the list is quite limited. And so the EU Commission now is looking at whether or not the UK will be able to benefit from this type of adequacy decision. So what happens? We said if it's granted, that's fine. Business as usual. If it's not granted, what happens? Well, then you're going to have to find another appropriate way to transfer EU personal data, and it gets quite tricky. So here's a list of a few things that you could already start looking into if you haven't already done that. And you should really prepare, because it's really not a given that on the 30th of June that the UK will have an adequacy decision. So the most common thing that's used is what we call standard contractual clauses, so SCCs. They're issued by the European Commission. They're currently under review. So there's a draft of these different types of SCCs that have been published. They've been submitted for open comments from different, if anybody who wants to comment. And the final version is expected hopefully within the next month or two. So that should be coming in soon. In the meantime, you have to use the current SCCs. And this is basically a contract that has been pre-approved and written by the European Commission that you add to your contracts with your partners in order to transfer the data. And in practice, it just enumerates all the obligations that each party has to make sure that all the personal data that's transferred is being adequately protected. Another means is the binding corporate rules, the BCRs, but these are only valid within a group of companies, and it can take up to a year to get an approval. So it's not something that's widely used, and it's mainly just for groups of companies. We won't go through all of these in detail, but just know that there are other possible ways of transferring the data. They're listed in Article 49.1 of the GDPR, and they include explicit consent. So if the people whose data you're collecting here in the EU give you explicit consent to transfer to the UK, you can do that. If it's for the performance of a contract, you can also do that. And then you have a series of other ways of doing that, like in the interest of the data subject, for important public, for reasons of public interest, for defense of a legal claim, and then a couple of others. So it's really important to look at how you can do that in your own specific situation. And it really is on a case-by-case basis. And if none of those work, then you can still find a few other ways to do it. But you have to make sure that the transfers are not repetitive, that there's a limited number of people to whom you're sending the data. And you have to look at, whose interests are protected or not protected, and make sure that you always keep the individual's interest at the forefront of any decision that you make. So it's an analysis that it's ongoing also. And these types of exceptions are really the last exceptions. So they don't apply that often. So make sure that you really look into the type of data that you're sending across to the UK to make sure that you can fit that into something here.
Yes, so here we want to just spend a couple minutes about the adequacy decision, because as Jane said, it's the very first step that would allow safe transfers from the EU to the UK. And we are in the middle of it right now, because since Brexit, there's this transition period that says that data transfers can continue freely, but the adequacy decision is ongoing, or at least the procedure is ongoing. So here you have a little summary of what a procedure looks like usually. We'll quickly go through it. So there's a draft decision by the Commission. After that, there's the EDPB who issues a non-binding opinion. Then the approval will be needed from the member states, so the representatives of the member state. And this is at this point that the decision will be binding. And also after that, the Commission adopts the decision. Now, it's important to know that at any time, as it's mentioned on the slide, the Parliament and the Council can step in and, give their own opinion and, on the process and on the procedure and on the draft decision. And so we'll go to the next slide here to see where we stand right now for this UK adequacy decision. So what are the last developments? So as you see in last February, the Commission issued the draft and they said that the UK was going to be adequate. So they found the UK to be adequate in these drafts. Now in April, as mentioned, so second step of the procedure, the EDPB adopted 2 opinions. As I said, they're non-binding, but at this point, the EDPB said that some improvements were going to be necessary because they didn't think that the UK was going to be adequate. So after that, in May, so 11th May 2021, you have the LIBE committee who, that issued a resolution that evaluated the Commission's approach to the decision. So what they said in this resolution is that they agreed with the EDPB, saying that the draft decision had to be amended because the UK they didn't find the UK to be adequate. So this resolution, really said that the draft was going to be amended or needed to be amended. Sorry. And then the last development, so on 20th May, so it was 10 days ago, the Parliament stepped in, as we mentioned, and voted in favor of this resolution to amend. So they said that they agreed with the resolution that asked for amendments of the decision. And then one day after that, so on 21st May, they said they confirmed that they wanted an amended version because they voted no to the non-amended version. So they said that they didn't want to validate the non-amended version of the UK draft adequacy decision as it stood at that moment. So really, it's interesting to note that right now it's the 1st of June and we don't really know what's going to happen next. We just have to wait and see. We're waiting for the decision from the representatives, but first of all, the Commission should reissue a draft. I mean, it would be the most, would make sense because as you can see, all these board and committees and Parliament all said that the draft needed to be amended. So they should make some amendments, but we're just waiting and see. We don't really know. And so, that's really interesting to note, to keep you updated of these developments and further developments that could happen up until 30th of June. Jane,
so what's going to happen after this deadline? So, well, we're not quite sure actually, because some people are already talking about a possible extension of the deadline. But from the UK side, they've already said that they don't want to use any type of extension. But we've all known in this Brexit saga how these extensions have been added at the very last minute. So we don't know. Could be, could not happen. But in any event, 30th of June is now, until further notice, the deadline. If there's an adequacy decision, no problem, business as usual. If there's no adequacy decision, then you really have to take supplementary measures and look into, all the exceptions that we discussed and what you can put in place. And as Romane mentioned, even if there is an adequacy decision, you always have to keep informed on the status of that decision, because the UK Commission has power to change it at any time. It can amend it, and it's automatically reviewed every 4 years. So maybe we're good to go for the next 4 years, and then after 4 years, they can just say, no, we're not renewing this because of that and that. And one of the important things to really keep in mind is the fact that from the UK side, they keep coming up with these new, declarations saying, well, we're not part of the EU anymore, and we do have the UK GDPR, but we don't have to stick with that. And it's a bit of an obstacle to trade. So we're going to maybe relax some of these obligations. So EU Commission has said, if you even touch the UK GDPR in any way whatsoever, you will not have the adequacy decision, or if you do and you change that afterwards, it's going to be a condition of getting the adequacy decision. So if you change that, we're just gonna, remove or delete this adequacy decision. So it's something that you have to really keep track of every day, basically. So most common misunderstanding about the adequacy decision is the fact that you don't need to wait for this for all the rest of the GDPR implementation or compliance. And this is very clearly said on the website of the ICO, so the UK Data Protection Authority, and the websites of the different data protection authorities in Europe. The adequacy decision, yes or no, has no impact on the obligation to appoint a data protection representative, either way, either in the EU or in the UK. So if you're doing business with the UK and you're waiting on this adequacy decision to appoint a representative, you're already not compliant, because they're two separate things and one does not depend on the other. So look at the conditions for the representative. If you need one, you need to appoint one. If you fall under the exceptions, great, but do not wait until the fate of the adequacy decision is determined.
Yeah.
So tips to prepare for 30th of June. Well, we went through those pretty much as we were discussing. So first step is really identify what types of transfers that you do of personal data to the UK. As we mentioned, it's not always so easy. It's not, if you're saying I'm not exporting there, I'm done, I'm clear. No, you have to dig deep and see everything within your company, everything that you're using. Are you transferring data? If you need to appoint a UK rep, then you have to do that as soon as possible. Has to be on your privacy policy, or anyway on your website, usually in your privacy policy, as Romane mentioned, because the outside world has to see that you have a rep, and that, what are the contact details if they want to contact the representative. And then you have to put into your documents and your privacy policy, everywhere that's needed, you have to be transparent, and you have to inform individuals, data subjects, and data protection authorities that you are transferring data to the UK, and you have to explain what types of measures you put in place to ensure that that data is safely guarded and that the transfer mechanisms are properly in place. So that brings us to the questions. And I see we have a couple of questions now in the Q&A from Alexander. Good morning. Thank you very much. We are a company inside the entertainment sector, and we maintain data on people visiting those centers. We do not process store data on our behalf, but on our customers' behalf. So you're a processor and not a controller. After Brexit, we migrated our UK customers to servers in London. UK customers remain in Amsterdam data warehouse. There is no transfer from EU to the UK. There is transfer from UK to the EU. As I understand it, there is very little chance we do need this representative. Yeah, Alexander, based on what you're saying, you're absolutely correct. Now, again, it's to look into, it's not just about servers, it's about the applications that you're using, an accounting service, or, payment portal, or anything else like that. So make sure that there is absolutely no transfer. That's for transfers. Again, if you're offering products or services from the EU to the UK, that's the criteria for a representative. It's not about transferring data. It's two questions. Do you offer products or services to people in the UK, or do you monitor their behavior? Those are that's the test to see if you need a representative. And
regardless,
yeah,
I just want to add, regardless of where you're processing that data, so the representative question has to be analyzed separately from the transfer question, because you might not transfer any data, but you might be from your EU office processing data of UK customers. And this is when you might need a UK representative, unless you also have an office in the UK, put simply.
Yeah. Because as you rightly say, Romane, if you have customers in the UK, you're collecting their data, but it doesn't mean that you're actually sending goods or services to there. So you're not necessarily, that you're probably offering products or services to them, but you're not transferring the personal data from people in the EU. So you're doing business with them in the UK, but all the EU data is staying in the EU. So there's no transfer, but you need a representative. So the two completely different things.
Yeah.
Then we have Frank. And what about research projects? We have just signed into a EU agreement for joint research with several UK-based institutions. It is inside the scope of our regular activities as a company, but it is not a commercial like the service. Yeah. If it's private, so if they're not public organizations, then you fall under the scope. We saw Romane when she explained that it doesn't need to be commercial activity. It could be non-profit associations also. If there is a collection or processing of personal data, even if it's research, we have a lot of clients who are in clinical trials for research purposes and things like that. You normally have to appoint a representative. So we'd have to look into your specific case. Yes, we do both. Alexander, yeah. So the non-public part then would probably be subject to representative. And then Leonid, what sanctions could be imposed to non-UK companies who do not comply with UK GDPR obligations? Well, it's the same as in the EU. So non-compliance with GDPR, the sanctions, they're not just financial. So the financial is from 4% of worldwide turnover to 20 million euros, whichever is the highest. There's a specific sanction for not appointing a representative, and that's 2% of worldwide turnover and 10 million euros. And they still refer to the euros part in the sanction part for the UK, so that needs to be converted into pounds. And for the rest, there are a whole bunch of other sanctions. So one of the most stringent ones, in my view, even probably sometimes more impactful than the financial sanction, is they can actually block the transfer of data. They can block access to your website, to your company's website. They can block the transfer of any type of personal data. So the powers of the ICO are very, very broad. So lots of different sanctions. Then Ian, is a company email address, B2B contacts considered to be personal data? Yeah, so as mentioned at the beginning, B2B operations also fall under the scope. You have to look again on a case-by-case basis. There's no general rule, but unless you're using generic email addresses like customer support at, accounting at, info at, where there's no name, there's no personal address, then you're okay. If you get into the personal address, even if it's in a professional context, in the B2B relation, then it could most likely fall under the GDPR or the UK GDPR. We have lots of questions. Yeah. Frank, it's clinical research indeed. Yeah. So indeed, we have dozens of clinical research clients, and they all fall under the scope of the GDPR and need a representative. Munif, do you think companies using CRM or online payment apps should always ask where their data are stored? Absolutely, yes. Absolutely. We have seen this. You probably heard of Schrems too. So this European court case where the European court said that any transfer of personal data from the EU to the States is now illegal. Who does not use Microsoft? Microsoft is American, so it's a transfer. And then it goes even beyond that. It goes to the fact that even if an American company has a subsidiary in Europe, where the servers are in Europe, the subsidiary is incorporated in Europe, so it's basically a European company. There's something called the Cloud Act in the United States, which means that the US surveillance authorities could request from that US subsidiary to have a copy of all the EU personal data. So that also falls under the scope. So you wouldn't even be able to use Microsoft having a server in Europe. But that being said, some data protection authorities in Europe, like the CNIL in France, have said, whoa, okay, this is not allowed, but it went to the Conseil d'Etat, and the Conseil d'Etat said, okay, this may be stretching it a bit. It's a risk, but it's a very low risk. So for the time being, it's tolerated. So to answer your question, Munif, it's not just for the UK that you have to look into this. It's for the US also, but the UK definitely, you have to look at your CRM, your online payment, everything. Where is your data stored? How is it transferred to make sure that you're compliant? Anything else?
And there's also questions in the chat. So
We have Veronique. We have a purely informative website, no sales on our products in English. Does this imply that we need a UK representative? If you're not collecting any data, Veronique, for example, well, it depends on your cookies. Do you collect the IP addresses for statistical purposes and things like that? That IP addresses are considered personal data, so that could be a yes. But you have to look at the website in general. If you're not really targeting and your website is just available in English to people there, then it should not necessarily be considered as you offering products or services or monitoring the behavior of people in the UK. That's the criteria. But again, case by case basis, look at all the different elements on, and there's a lot of, on the ICO's website, a lot of examples given, and you can contact us if you want, we'll have a look. But from what you say now, it doesn't seem like you would need a representative.
Yeah. There's also a question from Tom in the chat and then from Cedric. So if you're established in the UK, no UK representative is required, and wait for the adequacy decision. I believe this is correct.
So if you're established in the UK, no UK representative required, and wait for the adequacy decision.
Yeah, I believe that's correct. Because if you have an establishment in the UK, that you don't need a representative. If you also have offices. If you only establish in the UK though, and you don't have offices in the EU, you might need an EU representative.
Yeah, because it's right. Yeah, indeed, Romane, thanks. Yeah, right. So
contact us if you want more info on that, because we won't, just get you all confused with the double obligations. But
because the GDPR and the UK GDPR are all, it's a copy paste. So if you're a non-EU company based, so you're in the UK, and you don't have an establishment in the EU and you're offering products or services in the EU, you need an EU representative. And if the opposite, as I said, you're offering products or services to the UK and you don't have an establishment, you need a UK rep. So let's assume the following situation. An EU-based company renders services to various companies in the UK. So you're based in the EU, you're offering services to companies in the UK. The UK-based company has various partnerships in the UK. Yeah. The processing of the personal data is done by these partnerships in the UK, UK-based entities. Only generic information transferred to the EU, name of the company. How should you comply? Well, it seems that you would not fall in this case. I would have to look into it a little bit more closely, but you're right. If everything's in the UK and you're not transferring anything from the EU, no personal data from the EU to the UK, and it's only generic information, so it's B2B, then you should be fine. You have to just comply with your EU obligations, EU GDPR obligations, but nothing specific from the UK perspective. Tom, great, thanks for the clear answer and the full explanation. Hey, thanks, Tom.
More questions on the Q&A section.
On the Q&A, this is great. We never had so many questions before.
Oh, that's so interesting. Munif specified, I think, on his question.
Yeah, Munif, we're a public service. One of our main services is providing lists of contacts. How far are we involved in the GDPR rules? I guess it's the same for chambers of commerce or data providers. Interesting. It's not the same actually for chambers of commerce and data providers because they're private. If you're a public service, you don't need to have a representative. But all the rest of your obligations, Munif, under the GDPR and the UK GDPR apply. The only thing is you're not going to need a representative, but as a public service, you need a DPO, a data protection officer. So you need to comply with everything else, even the transfer, international transfer obligations. So you have to put those mechanisms in place. The only difference is with respect to the need to appoint a representative. That's it. The rest, it's full speed ahead with both GDPRs.
Yeah. There's one.
We are.
I think he was answering from.
A public, yeah, okay. Anya, based on this presentation, I understand we need a UK representative. Who should we appoint there? What are our options?
Well,
we're here.
This is the next slide. I'll just. There you go.
Our contact details. So we're happy to help. So as Romane was saying, we're based in Brussels. We have a separate entity. We're in the UK also, in the BLCC offices in London near Trafalgar Square. And we also have offices in Paris, Dublin, Berlin, and Madrid. So we're happy to help you. The thing is that Belgian companies like to work with us because we're also in Brussels. So it's a close thing. People call us up when they have questions. We're big GDPR nerds and geeks. So we like to answer questions. So you can call us anytime. So Anya, just feel free to contact us and we'll be happy to help you out with that. Then Diane, who could be a UK representative? We only have one employee and one contractor in the UK. Well, your UK representative could be a natural person or a company, but that person has to be able to handle GDPR requests. So you could use the employee or the contractor, but do they know about GDPR, UK GDPR sufficiently to be able to answer requests from the ICO or from the data subjects? So it's a tricky question. We get that a lot because people say we don't have a presence there, but they want to get on with their business and they want somebody else to handle the UK rep part. And the prices, of course, you know, the annual fees are tailored to smaller organizations. So sometimes it's best to say, okay, let's get professional people to deal with the GDPR. Everybody does their own, you know, specific business. So, you know, that's kind of the way that our clients ask us to perform that. But you would have to see with one employee and one contractor, yeah, you would need a rep. So you can use them. But the EDPB so the European Data Protection Board has said that you should not usually use a processor, somebody you have a relationship with, as your GDPR representative, whether it's the UK or the EU. So it could be internally or somebody that you don't have a relationship or partnership with. So that needs to be looked into. Have we?
I think we've covered all the questions.
Thanks, Chad. Do we have another one? Thank you very much. I think we're all set. No other questions? We're still here. Happy to answer any. I see some things coming up. Philippe, thank you both, Jane and Romane. Very clear presentation. Yay!
Well, feel free, as Jane said, to contact us via the email address here below, and we'll be happy to answer any other questions if you need. I'm just checking. Yep.
Jane and Romane, thank you very much for your help and for your wonderful presentation. Although I knew already quite a bit about it, I've learned a lot myself again. The questions were so detailed it reminded me of my exams at university. So I think you both have at least distinction. But it's also clear that everybody's situation is slightly different. So some extra advice will be appreciated by a lot of the attendees today. So ladies and gentlemen, thank you very much for joining us today. Feel free to contact Jane or Romane or indeed the BLCC. And I hope to see you soon, not at the webinar. Let's hope we can do live events soon. But we'll leave that one as an unanswered question because nobody knows. So once again, thank you for your attention and see you soon.
And thank you, Michelle.
Thank you.
Thanks, everybody. Bye.
Bye-bye.
And I think we have still one question there, Romane, if you have a second.
Yeah,
from
thank you. I assume you can provide assistance to review or write up any required extra clauses to adopt our contracts. Yeah, I think Jane left at the wrong time. No, actually, we don't provide any type of compliance counsel, or we don't act as lawyers and we don't act as DPO. I mean, even if our name is quite tricky, we don't act as data protection officer. The EDPB said that the roles of the representative and the other compliance officers, such as the compliance councils or anything, are not compatible, because as representatives, we act as the intermediary, so the point of contact, and therefore we only act under the instructions of the company. Whereas the DPO, who's going to be a compliance go-to person, or your lawyers or anyone, they have to be independent and they have to give you advice. They have to report to your company's highest authority, and they just, yeah. So those roles are usually not compatible. So we don't provide any of those services. We only focus on representative services to be able to provide really niche and focused, quality services. However, feel free to contact us to discuss, if you have questions. As Jane said, we're GDPR geeks, so we just love to discuss questions anytime. So yeah, just feel free to contact us anyway. I hope that helps.
Thank you,
Yeah.
Romane.
All right.
I think Frank understands
Okay. Well,
your answer very well. So thank you, Frank, for joining us today.
no problem. I'll stop the sharing, but feel free to contact us if you want. Thank you, Michel.
Everybody, thank you very much, Romane.
Bye-bye.
Bye-bye.
Bye.